case on this morning's docket is case number 106368, State of Kansas v. Page.
May it please the court, Janine Cox, Deputy Appellate Defender representing Mr. Page. Your Honor, I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Mr. Page was convicted by jury of 1 count of child abuse, 1 count of aggravated indecent liberties with a child, 1 count of aiding and abetting aggravated indecent liberties with a child, and 1 count of promoting obscenity to a minor. The trial court sentenced Mr. Page to 2 consecutive 25 years to life sentences and concurrent terms of 34 months and 12 months. Raised 6 issues in the brief. The state has conceded issue 5, the lifetime post-release issue. I would stand on the brief on issue 6, and as time permits, I'd like to address the other issues. The first issue concerns the admission of prior crimes evidence at trial. As the court will recall, there was testimony from a cousin of Mr. Page concerning prior sexual misconduct when she was a young child and they were living in the same house. The court held a hearing on the 455 evidence and allowed the testimony to come in. The testimony was challenged based on the fact that the evidence was not relevant and similar to the case that was at hand. As you recall, there was some strikingly dissimilar components to both of the events. The prior crimes evidence was with, although a child, it was a girl. The prior crimes evidence was a different act than the act that Mr. Page was being charged with and tried on. There was a difference that there was a co-defendant in the second case as opposed to the first case. The case was also decades in the past. Although both were minors, it was a decidedly different sexual misconduct, and the argument was made there, and the argument continues to be made here, that evidence should not have come in. There was a question about whether this should be reviewed under the old statute or the new statute. My argument would be regardless of whether we are using the latest version of 455 or the prior version of 455, that the evidence should not come in. Even if you look at subsection D of the new statute, and I'm quoting here, evidence of the defendant's commission of another act or offense of sexual misconduct is admissible and may be considered for its bearing on any matter to which it is relevant and probative. The argument is that that's D section is the section that's referred to as the propensity section, that any propensity evidence can come in. But if you look at the language of the statute, on any matter to which it is relevant and probative, if the legislature chose to put into the statute the term relevant, it must have contemplated that there would be those cases where evidence wasn't relevant. And if that's the case, then propensity cannot just be anything comes in anytime, all the time, every time. And the argument here, as I stated, is that this evidence, CR's testimony, was so dissimilar to the act for which Mr. Page was tried and convicted on in this case, that evidence should not have come in. It was so dissimilar and therefore contemplated by the statute, not relevant in this case. That testimony was, as the court, I kind of move into the sufficiency argument, that testimony simply bolstered the argument that if we're making the argument that there was not sufficient evidence here, if you remember the facts of the case, there was no physical evidence in this case. There was no evidence to show that any, no physical evidence, no biological evidence. There was nothing that of a physical nature to show that this happened. The only evidence against my client in this case was the testimony of the accomplice. The accomplice in this case testified these things happened, and as the court will recall, that testimony was a requirement. He turned state's evidence. That testimony was a requirement that he testify against Mr. Page in order to cut a deal with the state. So the only evidence was this accomplice evidence, and there was some evidence from two other individuals who I believe were told that this happened, that the events happened, and those people were related to the accomplice. And that's the only evidence that came in to ever suggest that the crimes, the Ag and Decent Liberties crime, that's what I'm focusing on here. That's what the 455 evidence goes to. That was the only evidence against my client in this case. And if the court will also recall, there was the child abuse charge. My client, in a statement, admitted to that charge. So the evidence of the event, the Ag and Decent Liberties against this 3-year-old child, was nothing more than the statements of the accomplice who received the benefit of a lesser conviction based on that.
I know you're objecting to the admission of the testimony of the Sane Sart testimony,
Yes.
but didn't that corroborate the state's case? That clearly did, didn't it?
Ms. Hollins, should I answer that question before I argue why I think her testimony should come in?
You said there was no other evidence.
Okay.
This was evidence that was admitted. It seems
There
to me
was-
that's pretty strong corroborating evidence.
There was evidence from her concerning the scarring that was found.
That could have happened 5 days to
Could have happened 5 days
to a couple of weeks,
to-
which was within the time frame.
It was within the time frame. However, in the scheme of things, her testimony, and this kind of leads me on a path that I've not particularly wanted to go, but her testimony at some point was rejected. At least part of her testimony was rejected because she's the only person that testified to penetration, that any penetration occurred. That was her testimony. And yet the jury convicted on the Ag and Decent Liberties rather than the Ag criminal sodomy charges, which would have required the penetration. So there was that testimony. However, her testimony was not ever, she was not deemed an expert. She was a Sane Sart nurse. I know that to be true, but she was not deemed an expert. My argument would be that even with that testimony that something happened, she certainly couldn't testify that my client did that or that happened even on the day that the accomplice testified to that. So although the testimony was that in her view something had occurred, she could obviously not say when it occurred, and she could not say who was responsible for it. So in terms of direct testimony about the event itself, the only testimony was J.S.'s testimony.
I want to swing back to the 6455.
Okay.
Just so I'm clear, do you concede that the new version of the law is applicable given our case law? I mean, we have to overrule cases in order to apply the old law. So your argument is the new law applies and it's relevant and probative that we're supposed to look at to decide
You
this.
know, I'm always reluctant to concede, but it's, the Torres case is still out there, which is a case that I cited in my brief, which is very similar, and it doesn't appear to me that the court actually overruled Torres. Maybe it did and I missed that. But Torres was very similar to my case in terms of the time frame, and this court said that we will apply that, the old version of the statute, because that was the version that was in effect at the time the crime was committed and at the time my client was convicted. But if I don't necessarily say the words concede and discuss the new version, my argument is still that that new version, because of the language in the statute, indicates that it may not be as all-encompassing as we have discussed in other cases about propensity. If that's the case, if it was just propensity, then it seems to me that the term relevant might not be in there, but the statute still requires that the evidence be relevant, which suggests to me that there could be those cases where it's not relevant, and therefore doesn't fall into that broad category of propensity evidence. I don't know whether I've answered your question at all, Your Honor.
Well, we have the Hart case and the Prine case, and all of those are later than Torres,
Correct.
and both of those cases say the exact opposite from what you're trying to say. So it just seems to me that we're focused then on the new statute.
Okay, and I'll
if that's
focus
the
on the
case-
new statute and still make this argument
Okay.
that the new statute maybe is not as all-encompassing as we thought. I would note that the Prine case and I think Council 609, the Moyers case, those two cases are factually distinguishable in a certain sense, in that I believe both of those cases, the evidence to be brought in on the 455 had to do with prior sexual conduct with the same victim. My case clearly is different from CR's testimony to the testimony of at this trial. I see I'm out of time. I would just briefly say on the issue of Ms. Holland's testimony and whether that was sufficiently, it was not necessarily the due diligence of the state to find Ms. Holland and bring her in, but whether the authentication of that doctor's note on a prescription pad that said she was relieved from trial duty seemed to be not meet the standard that would be necessary to have somebody deemed unavailable and have her testimony read from preliminary hearing. I would also point out that preliminary hearing, and I understand well because I've lost that case more than once, that there's no right, if the preliminary hearing has defendant has been given an opportunity to cross-examine at preliminary hearing, that confrontation has been met. But I would note that in this case, once again, that the trial counsel at preliminary was different than the trial counsel at trial. On the remaining issue about the introduction of the photographs, the number of photographs, and I understand that those photographs go to the promoting obscenity to a minor charge, but it did seem that it was the proverbial using a baseball bat to hit a gnat in terms of the number of photographs that were admitted at trial.
Let's talk about that. The objection at trial was what?
I believe the objection at trial, and I may be wrong, I'll look it up when I see it.
It was relevant.
That they
So
were
do you
relevant.
get to talk about prejudice when you get up here? I mean, is the issue preserved?
I'm not, if you're saying that whatever the record says, that's what the record says. If it was only on relevance, whether it was relevant or not, yes, I think it's preserved. I can argue that it was prejudicial. Even if it was deemed,
Is it deemed irrelevant because it was really, really harmful?
yeah, I could go with that. It was very harmful.
Do you have any authority for that argument?
No, not off the top of my head, but it was very harmful. If the court has,
Well, we wouldn't want harmful evidence to get admitted
well,
against any.
not when it's coming in the massive amounts that it came in that.
Is
in that
cumulative
instance.
evidence irrelevant?
I'm sorry.
Is cumulative evidence, if it's unduly cumulative, if you've got 200 photographs and they all show the same thing, then you get to the point where you can call the
Excess.
repetitive not making it more probable than not that the fact exists.
Yes, that could be a good argument. It could also be mind-numbing to have that number of photographs admitted. If there are no further questions,
Any more questions?
I would ask the court to reverse and remand either for a new trial based on the errors that were made, or to reverse and remand for insufficient evidence.
Thank you, counsel.
Yeah.
May it please the court, Chris Elsleger, appearing on behalf of the state. There were no errors in this trial that warrant reversal of the convictions. Beginning first with the 6455 evidence, that evidence was relevant to establish the defendant's propensity to commit sex crimes and his intent. The new 6455 is applicable. The case law says so, and it allows propensity evidence. That's a pretty low threshold. I mean, it shows that this defendant had a sexual attraction to children.
If that's the relevance here is that if they were minors.
That's part of it. That he clearly had trouble controlling his sexual urges, and that he believed he could get away with it. It was also relevant to intent. He did offer innocent explanations. He claimed that the injuries to the little boy were caused, at one point he said, just because he spanked him too hard, and then later he made up this story about seizures and how he was holding him down when he had a seizure. So when a defendant offers innocent explanations for the events to explain it away, intent is an issue. And that is one of the other recognized reasons under 6455 for admissibility. So I think on both of those grounds, it was admissible, and the court did not abuse its discretion in admitting the evidence. And I would also highlight that the standard is abuse of discretion, which is a high threshold for the appellant to meet. So, with respect,
Counsel, let me tell you what's bothering me on
Yeah.
this case, and that's the doctor's notes. They just seem to sort of float in here and get accepted, and I don't see how our rules of evidence, which I think are applicable, how those allow these unsubstantiated, just doctor's notes to come in without something more.
well, I think that you have to look at it in the whole context of, I mean, the prosecutor also, when the jury was removed, the prosecutor was sworn in as a witness for the purpose of explaining, what the state did, what the state knew about Miss Holland's condition and what they did to try to either, to get her available, or, to explain why she was unavailable. And that laid the foundation for the note. So there was more than just a doctor's note that came in. I mean, the prosecutor explained, the day before, or the day of trial, midway through the trial, they got a phone call said that she had suffered a stroke and was in the hospital, and she was subpoenaed, I believe, to testify the next day. So there wasn't a lot of time. What the prosecutor did was, called the hospital, was able to actually talk to her, but she was, in the hospital on medication and everything. Then she sent one of the employees of the office to the hospital to get some kind of written documentation. And would it have been better if the doctor would have written a sworn affidavit or would have come in and testified? Sure, but under the circumstances, I think they did the best they could. Doctors, from my experience, do not like to just drop everything and go to court. I mean, they focus on taking care of their patients and so on. And there wasn't a lot of time, and it wasn't just a note scribbled on a Post-it note. This was on a prescription pad, which is a sensitive item. It's a controlled item. They don't just hand these things out. This is what they write prescriptions on that go to pharmacies for the distribution of drugs. So if you look at it's in the record when you look at that prescription pad note. I mean, there's it says on there it's got I think something like a certain number of embossed security features. It's it's got the barcode on it. It looks official. It's got the doctor's signature on there. And I think that under the circumstances of less than 24 hours in which for the prosecutor to try to kind of get this together for the court, I think the court acted well within its discretion in believing the prosecutor's sworn testimony and finding her credible and finding that this note was in fact what it purported to be. And I would point out to the prosecutor was subject to cross-examination. She was under oath. Opposing counsel didn't cross-examine her. Didn't really. I mean, what? In the end, do we really believe the prosecutors made this up and is lying about one of their witnesses suffering a stroke? I mean, the prosecutor would much rather have her live testimony than have it read from the preliminary hearing.
Counsel, I'm a little unclear. Are you agreeing or denying that the rules of evidence would have applied to that piece of evidence?
Well, I think the rules of evidence would apply, but I think the foundation was laid by the prosecutor's testimony for the judge to find that it was credible, that it was what it purported to be, and that it was admissible and could take that into account. Now, of course, you can throw that out.
Authentication of the note is one thing, but admitting it under a rule of evidence is another. So if you could remind me what the evidence was admitted under. Was this a hearsay exception?
I don't recall what the exact objection was. I mean, that's the first step is if there's no specific objection, well then there's nothing for the other side to argue about. Now I would have to go back to the record and look and see what the objection was. It may have been hearsay. I don't know which. I honestly don't know. I don't know what the objection was. I think you could argue that it could come in as an official document. It could racking my brains for the rules of evidence. I don't recall what the exact objection was, but I think that with the prosecutor's testimony, there was certainly foundation laid. There was, I think, enough for the judge to find it authentic, and there's indicia of reliability there to admit it. And so this isn't a case where there's a confrontation issue, because this wasn't a testimony against the defendant. This was just evidence being used to show the unavailability of a witness. And I suppose, and I haven't delved into it in that context, perhaps the rules of evidence are relaxed.
Yeah, I just wanted to back you up on that because I'm a little confused by your position. You said you thought the rules did apply, and I understand that they might apply because of the procedure used here, but they wouldn't inevitably be applied to whatever is represented to the court about the unavailability of a witness, would they?
Yeah,
That's not always done in a sworn statement, is it, from a prosecutor?
I'm sorry, what?
That's not always done or inevitably done in this manner, is it?
Yes, you're right. As the gears in my brain are turning, I think that is correct.
Yeah, I just thought you might want to walk that back a little bit.
I mean, sometimes the prosecutor will just explain to the judge, here's what happened.
I thought that was pretty typical. I thought this was going the extra mile. And given that, is it really necessary that we had a doctor's note? Can't the prosecutor, just as an officer of the court, tell the judge, these are the steps we followed to get this witness here? These are the reasons we were given why the witness isn't here?
Absolutely. That was my fallback argument. I was going to say, even without the note, we have the prosecutor here who went the extra step and gave sworn testimony under, subject to cross-examination, that this is what happened. And the judge is then within his rights to find that credible and believable.
And admissibility for purposes of a preliminary evidentiary ruling is different from admissibility before a jury, isn't it?
I will agree with you on that.
It just seems like you have a lot of avenues to go here to protect this from any kind of ruling on reversibility.
I would agree with you on that as well.
Okay.
I think there's plenty here for the judge to make the determination. It really is. It's kind of hard to imagine that the prosecutor, as an officer of the court, would come in and lie to the judge about a witness being unavailable. Is actually pretty critical to the case. And then, of course, ultimately there is the harmless error argument that, the critical piece of her testimony had to do with penetration, and of course the jury acquitted on the charge.
What about that?
Penetration.
Does that then the jury acquits on what the real relevant evidence from part of the relevant evidence of the SANE SART nurse was going to testify to? Does that evidence go to the ag indecent liberties?
Well, I think it could, but I think in a harmless analysis, when you look at the prejudice, it certainly couldn't have been that prejudicial when the jury acquitted on the one crime where she was really the sole source of evidence. I think there's enough evidence. You could take her testimony completely out, and there's still more than enough evidence to convict on all of the other crimes. So I think it just factors into the when you're looking at harmlessness, that it certainly was harmless in this case. Does that answer the question? And that leads into the sufficiency of the evidence. I mean, clearly the case law says that the testimony of an accomplice is sufficient in itself, and that's what we had here. We had J.S.'s live in-court testimony subject to cross-examination. Not only that, we also had his confession, which was given long before he went to court, long before he made any plea deal, and that confession was that he gave the police was absolutely consistent with the testimony at trial. We also have the testimony of the statements that he made to others about the incident before he ever talked to police, and before he ever made any kind of deal, before he even contemplated going to trial. That was consistent with his trial testimony. There was physical evidence as well. The little boy had injuries. That's what started this whole thing. He had bruises all over him, which is what started the investigation. The SRS worker said that it looked to her. I think what she said was that from the type and location of the injuries, that it suggested sexual abuse to her. So that shows that you could, a reasonable inference to draw from the physical injuries was sexual abuse. So that goes into the pile of evidence when you're looking at the sufficiency of the evidence. So when you add all that together, I think it's pretty clear the evidence was sufficient to sustain the convictions. And then finally, with the admission of the photographs, I would just say that he was charged with providing obscenity to a minor. The photographs themselves were the instrumentality of the crime. They were the crime, so they were clearly relevant. And I don't think that the prosecutor should be required to minimize the crime just because, the defendant didn't stop at 1 or 2 or 10 pictures, so I don't see why the prosecutor should be required to water down the crime and stop at 1 or 2 or 10 pictures. The prosecutor presented all of the pictures that created the crime. And I don't think there's any issue with that. It certainly was relevant. And if there are no further questions, I would ask the court to affirm the lower court.
Any more questions? Thank you, counsel. You're reserved 3 minutes for rebuttal.
Unless the court has questions, I've waived my rebuttal.
I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.